Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you, and counsel, welcome to the Fourth Circuit. We have 4 arguments today, but we got a little bit of an unusual situation in that we're going to have different panels for the first case compared to the other 3. So for everyone's planning, we're going to take a break and a recess after the first case, and then we'll come back and do the next 3 cases. But with that background, we'll begin with our first case, case number 20-1937, and look forward to hearing from Joe White with Mr. Oring.
Thank you, Your Honor. May it please the court. My name is Ira Oring, and I represent Joe White Limited Partnership. Joe White has brought this action to recover for the collapse of Building 300 of the Joe White Apartments, which is a 2-story, 8-unit apartment building that's owned by Joe White and insured by Federal Insurance Company. We seek to hold Federal Insurance liable under the terms of its policy that it drafted, consistent with principles of Maryland law. There is coverage under this policy because the following facts are undisputed. Number 1, Building 300's foundation was defectively designed and constructed. The building was located in an area of organic soil. The foundation did not go deep enough, nor was it constructed appropriately, causing the building to sink under its own weight. One side of the superstructure was about a foot higher or lower than the other. There were large cracks in the brick facade. The windows were inoperable, and the building was not occupied for several years, and still is unoccupied, of course. Building 300 suffered a collapse. Collapse is a recognized peril under an all-risk policy, such as the one in this case. It was not excluded by Federal Insurance. Under Maryland law, if not otherwise defined, which it was not here, collapse is any serious impairment of structural integrity. And as we indicated in our brief, Federal Insurance admitted when we made requests for admissions that indeed Building 300 had a serious impairment of structural integrity. The collapse was due solely to the defective design and construction of the foundation. There was no issue with the superstructure. We quoted Federal Insurance expert Nicholas Palumbo at page 20 of our brief, where he stated you could have other problems, like I say, with the superstructure that weren't evident, but it appeared that the building was acceptable and the failure was with the foundation.
So, counsel, it sounds like the collapse is the damage. The collapse is the result of the problem with the foundation.
Well, Your Honor,
is that right?
Something can be both a peril and the damage. And I'll give the court an example. Fire, for instance. Fire is the peril and the damages are fire damages. The same is with water. Water is the peril and there are water damages. And the same is with collapse. Collapse can be both the peril, it's a recognized peril, as well as the resulting damage. The issue
what is the damage what damage did the collapse cause?
Well, the damage caused the issues that I've already indicated, which is the fact that the one level of the building was set a foot lower than the other, that there were cracks in the facade, the windows did not open. In fact,
that is the collapse, right? The structural integrity, the impairment of the structural integrity is the collapse.
Yes.
So a collapse can be a peril and a result, but surely not in the same case. Here you're defining the result, the damage, as collapse, and also trying to say that the collapse caused the collapse.
Well, I'm defining the damage resulting from the collapse. So if there's a fire, the fire is the peril, and there are also damages solely resulting from the fire. It's the
right,
same.
But the damages are not fire. The damages are things like something was incinerated, something is missing because it is burned up, or there's smoke damage. It's not fire is the damage, it's the results of the fire.
And here
it looks like your collapse is the damage that was caused by what you're calling the collapse.
Well, and I think that is exactly the issue that was confronted by the court in the state of Washington case, which is Vision 1, where the defendant stated that the collapse can't be both the peril and the damage, and the court held that it was. Because
no, there the collapse was the peril because something collapsed onto another thing and caused a separate damage. Collapse can surely be a peril and a damage, but in that case, it was the peril that caused a different resulting damage. Your problem in this case is that you need collapse to be the peril, not just the result, not just the resulting damage. And it seems circular to say the collapse caused the collapse.
Well, there was a serious impairment of structural integrity of this building, and that is the definition of a collapse. As a result of that serious impairment, there were damages that resulted. One set of damages was the fact that the building, the superstructure gave way because the foundation was not constructed appropriately. And as a result of that, there was other damages, such as the fact that windows wouldn't open. There were large cracks in the brick and things of that nature. It was unstable. So I think that the failure to appropriately construct the foundation led to a serious impairment of structural integrity of the building. And that's
Counsel, to follow up on those questions, doesn't if the effect of the faulty construction is collapse, the direct effect, doesn't your position that collapse can be both the damage and the peril, largely nullify or the exclusion?
I don't think so, Your Honor, because the exclusion, what was improperly constructed here is the foundation, and we're not seeking recovery for the foundation. The foundation and the superstructure are separate and apart from each other. The policy.
Well, even if I understand that argument and understand how building is defined, so I appreciate what you're saying there, but nevertheless, you're saying that the direct effect of the faulty design, the collapse, is a separate peril. And it seems like the effect of that, at least in this case, maybe not in all situations, is that you've rendered meaningless the exclusion.
Yeah, I don't think so, Your Honor. And the reason is, as Judge Hollander expounded in the Bethany Boardwalk case, Maryland is not one of those cases. Unlike Virginia, for instance, it requires that Virginia requires there to be attenuation, a separate and direct intervention between the effectively constructed properly and the resulting loss. Maryland does not require that. Under Bethany Boardwalk and Selective Way, for instance, where Selective Way is a good example where the defective coupling of the water cooler directly led water to leak into the building. And the leak
go ahead. I'm sorry, Judge Austin. Go ahead.
Isn't it true in Selective Way that there were different contractual provisions which defined the liability?
I don't think so, Your Honor. I think that in Selective Way, it was a case just, I think, like this one, where there was defective workmanship that directly caused the water damage to the interior of the.
If I can follow up on Judge Rushing's question just a little bit. Whenever we're talking about general liability law, whether it's negligence or contractual liability, we have separate inquiries as to proximate cause and damages. And it seems from your argument, and correct me if I'm wrong, sir, that you're merging the two. How can you have proximate cause and damages be the same inquiry?
I don't think I am, Your Honor. The efficient proximate cause is I think, a separate issue that deals with whether one exclusion or both exclusions apply, whether the exclusion for settlement applies, as well as the exclusion for defective workmanship, which we think clearly under Maryland law, you look at the efficient proximate cause to see what exclusion applies. Then you look at whether there's coverage under that exclusion. And I believe that the defective design and construction of the foundation has an ensuing loss clause, which indicates that it provides coverage for a peril not otherwise excluded, and collapse is not excluded. I think this case is very much like Selective Way, where the ensuing loss flows directly from the excluded event, but under Maryland law, that's permissible, and that is the test under Maryland law, as long as it's to different property. And we believe,
counsel, to follow up on the Selective Way, I mean that's not a Maryland state court case, is it?
No, it isn't. It's a federal case, Your Honor. Applying Maryland law. And I appreciate the similarities in your argument in that case. But is there a Maryland state law case that says the ensuing loss does not need to be from a separate event? Your Honor, I think that there are certainly Maryland cases that have indicated that in connection with, for instance, the McAvoy versus Security Fire case, where the Court of Appeals found that for direct loss caused by an earthquake, for instance, there's no coverage, but there's coverage for the loss caused by a fire that directly ensues, so that the fire is caused directly by the earthquake. And if you look at Bethany Boardwalk, which is also a Maryland U.S. District Court case, it analyzed, going back to the early 1900s, Maryland law regarding ensuing loss, and came to the conclusion that, unlike for Virginia, for instance, Maryland does not require attenuation, specifically distinguishing the court in Taha in Virginia, which said that attenuation is required. But it's not only the Maryland courts. Taha relied upon Selective Way to say that Maryland does not apply the consensus view, that Maryland does not require attenuation, as did the court in Leap, which is another U.S. District Court case in Montana. So I think it's pretty clear, both from state and federal law, that Maryland views the ensuing loss it can flow directly from the excluded peril. I did want to take a minute or two, if I could, to address the efficient proximate cause rule and the district court's determination that it does not exist and that the settlement exclusion bars coverage. And I think the crucial point here is that there are 19 exclusions that are applicable in the business and property coverage. 8 of those exclusions contain anti-concurrent cause language. The other 11 don't. And none of the exclusions that are relevant to the coverage in this case contain anti-concurrent cause language. But by denying the existence or refusing to employ the efficient proximate cause rule, the district court basically read all these exclusions the same. The district court found that any exclusion would be sufficient to bar coverage. And that would read out the fact that some exclusions have anti-concurrent cause language and some don't. And we have to ask ourselves, if Chubb believes that the efficient proximate cause rule is not applicable, then why did it include anti-concurrent cause language in its policy? Anti-concurrent cause language, of course, indicates that no matter where the exclusion falls in the chain, there's no coverage. And that is for instance, the nuclear hazard exclusion says that it is applicable no matter what other event contributes. And there are 8 of those exclusions that employ efficient proximate cause language, and there are 11 that don't. And I would just point out that, as I indicated in our brief, in responding to our request for drafting notes, in order to determine why some exclusions have anti-concurrent cause language and others don't, Chubb raised the efficient proximate cause rule, and it cited the Hartford steam boiler case, which is the grandfather of all cases in Maryland, indicating that courts look at the efficient proximate cause of any given event. And although there may be subordinate and determinate causes in order to determine the rights and liabilities of the parties. And I refer to Chubb. It's Federal Insurance is a division of Chubb. And we agree with Chubb as to what it wrote in that submission to the court. It's not at all clear whether Chubb still agrees with what Chubb wrote, given the fact that its brief is not clear whether it embraces the efficient proximate cause rule, but I think it's quite clear from the case law that is the law in Maryland, and that anti-concurrent cause language is used to abrogate the efficient proximate cause rule. And in this case, the settlement exclusion is a subordinate cause. It's not the predominating cause in producing the result here. I also think it's clear that the collapse was an ensuing loss, and I think just as in the state of Washington case, Division 1 case, it's both the damage and the peril. I see my time has run. Thank you.
Thank you, counsel. You have some time left on rebuttal. We'll now hear from Mr. Green.
Good morning. May it please the court. Bryant Green on behalf of the Federal Insurance Company. And what I'm here to do today is to ask this court to apply the plain and unambiguous text of the policy, nothing more, nothing less. Direct your attention to page 64 of the joint appendix, where the planning design materials or maintenance exclusion is found. And before we even get to the ensuing loss language, I want to direct your attention to the first paragraph. And it says, this insurance does not apply to loss or damage, skip the parenthetical for just a moment, caused by or resulting from any faulty, inadequate, or defective, and then there's a list of things. Now, what Joe White would have this court do is say, that the text doesn't actually say that. What it says is this insurance does not apply to only the defective building itself, regardless of any loss or damage caused by or resulting from the materials that follow. As if that language wasn't clear enough, we do have a parenthetical that says, including the cost of correcting or making good. What that parenthetical tells us is that, yes, the defective material itself is included with that in exclusion, but it's also intended to apply beyond that. That's exactly what Judge Sutton determined in the Sixth Circuit in TMW. That's exactly what the Northern District of Florida, upon which Judge Berdar relied in selective way, and that was from the Bartram LLC. And that language shows us that the text is supposed to apply beyond the defectively constructed material itself. Now, going down to the ensuing loss exclusion itself, it says the planning, design, materials, or maintenance exclusion does not apply to
just a moment.
ensuing loss.
Counsel, if I could interrupt for just a moment.
Yes.
Obviously, we all understand this case went out on a Rule 56 summary judgment, and it appears that there's at least some disagreement amongst the experts in the case, one for Joe White, one for your side, as to causation. Since there is a dispute as to causation, why shouldn't a fact finder make the determination as to whether or not the circumstances of the contract apply in light of the differing opinions of the experts?
I don't think there is a dispute of fact as to causation. I actually do agree with Mr. Oring on that. The experts do agree that defective construction contributed to this. Now, our experts say something else contributed as well, and that was settling. And between the defective design and the settling together, it caused the loss. Now, for that, you get into this almost philosophical discussion about what is a cause. And, you could go to your first year torts class and talk about Paul's graph and Long Island Railroad and Judge Andrews' dissent, where he says, look, there are infinite causes for any particular phenomenon. And that's true. We could go to the dawn of time and find things that contributed to this loss that aren't an issue in this case at all. Now, I actually also agree with Mr. Oring that in general, the efficient proximate cause rule will help us determine what exclusions to apply. Mr. Oring cites me to my own letter of 2019, and then we also look at Judge Grimm's opinion in McWhorter. I'd submit to you that I argued the McWhorter case, and if you look at the text of that opinion in my brief there, it's the exact same language. I'm not denying that the efficient proximate cause rule applies. I'm saying that in a situation like this, the exclusion itself makes it so that the exclusion is going to apply unless there's a peril not otherwise excluded. So the planning and design material maintenance exclusion itself incorporates the remainder of the exclusions. So we're not denying that this was caused by defective design. We agree with that. We're saying in addition to the defective design, it was also caused by settlement, both of which are excluded. Even if this court was inclined not to agree with us with regard to settlement, and I submit that it probably should agree with us with respect to settlement, just as Judge Boardman did, that's still a sufficient basis in itself to reach the right conclusion with regard to the faulty workmanship exclusion. Did I answer your question, Your Honor?
You're fine, thank you.
So going down to the exclusion, we see that there are three elements that must exist. One, an ensuing loss or damage. Two, caused by or resulting from a peril. And three, that peril must not be otherwise excluded. Now, there's been much made ado about the distinction between a consensus approach and whatever the alternative that Maryland would apply. Now, I think it's already been indicated that there has been no specific Maryland state court authority rejecting what this court has previously adopted as the consensus approach. But the only the authority that we have is from McAvoy. And I refer you to that case. It actually comes from the genesis of ensuing loss clauses, the early 1900 San Francisco fires. And in those cases, the problem was we had an earthquake, which were generally excluded, but we had all these subsequent causes. When the buildings fell, fires ensued, looting ensued, crime, all this kind of parade of horribles. And people wanted to shoehorn their coverage into the earthquakes. And so the distinction that the court drew way back in the early 1900s was between earthquake on one hand and, quote, independent destructive forces on the other. Now, we're not talking about specific ensuing loss language or, independent, the more modern language, but we are drawing a distinction between multiple independent destructive forces, and that's what the text of this policy requires. Moreover, even selective way was decided before this consensus approach discussion in the Fourth Circuit in the Eastern District of Virginia got started. Even then, Judge Berdar was determined that the water loss in that case was, quote, a step removed from the faulty workmanship and was not directly caused by it. So even though the courts have been talking about this distinction between a consensus approach on one hand and whatever the alternative is in Maryland is on the other, we are still drawing distinctions between different causes. The same isn't true in Bethany Boardwalk, where Judge Hollander says that that the roof damage was, quote, inextricably intertwined with the faulty workmanship. He's saying that the damages are so entwined with each other that they can't be distinguished, and that's what's true in this case. Moreover, they said that Judge Hollander said in that case, an ensuing loss provision does not cover losses caused by the excluded peril, but rather causes loss to other property wholly separate from the defective property itself. And there is no property wholly separate from the defective property itself in this case. Now, as we go back to the text of the policy, this exact policy, the exact same language we're talking about today, has been determined by 8 different judges across the country to apply just as federal is advocating right now. Once at a district court in Michigan, 2 judges, including Judge Sutton, adopted this position in TMW. One, very critically, is in Judge Berdar's opinion in selective way, he was relying and said that this case is on all fours with and squares with the Barber and LLC, which is a Florida case. In that case, the court was presented with 1, Judge Sutton's opinion in TMW, and 2, alternative policy language in another case. The court drew a distinction between Judge Sutton's opinion in TMW and the policy at issue in that case based on the exact parenthetical that exists in this case. And that in itself alone indicates that this policy, in and of itself, the text should be interpreted as federal has advocated in this case. Moreover, this court, albeit to strike that, when this court brought up the idea of a consensus approach as an alternative to whatever Maryland law applies, that distinction, this consensus approach language, was a per curiam opinion from this court, basically adopting the district court. Now, what's interesting in Taja, the case to which I'm referring, the court did not reject outright Maryland's application of this consensus approach. It said they are reluctant to impose it. And that even in selective way, when we look at it, Judge Berdar made clear that he was interpreting the policy that the policy is interpreted according to its terms. And that is all federal is asking in this case, for this policy to be interpreted according to its terms. Now, while the Court of Appeals has not spoken directly on the subject of ensuing loss provisions in recent years, what we do know about Maryland that distinguishes it from Virginia and many other cases is in many other jurisdictions is that Maryland maintains strict fidelity to the terms of the policy itself. Unlike many jurisdictions that interpret policies in favor of the insured, Maryland does not, and it only does so in case of an ambiguity. Here, the parties agree that there's no ambiguity. The court has ruled very early in this case that there's no ambiguity. Given that that's the case, there's no excuse for interpreting the contract in favor of an insured, but rather we should apply the plain terms as they are written. As such,
so counsel, if I could just make sure I'm understanding, your description of Maryland law and with respect to the question of whether the ensuing loss applies to some separate event. It sounds like you're saying you're not entirely sure what Maryland law is, but it at least requires something, identifiable like a independent force in the case of a fire with an earthquake. I just want to make sure I understand your position on whether any separateness is required in terms of our analysis.
Now, yes, I do believe that there must be an independent destructive force. I believe that in order to constitute an ensuing loss, there must be an alternative legal but-for cause. But what I would caution, what I would advocate for, is I don't think it's necessary to espouse a bright line rule that applies to all insurance cases. So, for example, in tort cases, in Maryland, we apply contributory negligence, and in most other jurisdictions, we do not. That's because those rights come from the jurisdiction itself. It's the court's responsibility to articulate what those rights are. In a contract case, by contrast, the parties' rights are determined by the contract itself. So it's probably inappropriate to say, as a matter of all ensuing loss provisions from now till time immemorial, we're going to apply consensus approach or not. Rather, what I think Maryland courts do very consistently and very regularly and rightfully is they take a critical look at what the text of the policy says. If the text of the policy is ambiguous, if it doesn't have things like this particular parenthetical in this one, if it's worded differently to suggest that the ensuing loss clause could apply more broadly, then yes, interpret the policy as written. But here, the policy that we have in this case specifically indicates, so you would have to throw out the, so yes, I do believe that alternative covered legal but-for cause, but I don't think it's necessary to espouse an overbroad rule in this case. And I think mistakenly purport that I'm directly quoting her, but in the most extreme cases, the ensuing loss is going to be a but-for cause. But I think as Judge Rushing observed in her question, that's not true here. You cannot say but for the collapse, the building would have sunk. You cannot say but for the collapse, the window would have opened. The collapse is not a cause at all. It's an adjective. It's a description of what happened. It's a state of the existence of the building as it is in present. It's not something that happened in time and space. Mr. Oring referred this court to Vision 1, where, as Judge Rushing accurately observed, that involved a collapse of a structure down on top of another, causing additional damage. What Mr. Oring omitted reference to is Sprague versus Safeco Insurance, decided the exact same day from the exact same court. In that case, there was a building with an exterior deck with fin walls, and there was moisture intrusion, which caused a impairment of structural integrity, just like the case here. Now, the deck didn't fall.
Counsel, let me ask a question if I could. And you've relied on the fact that the terms of the contract are going to be the most significant thing that this court can consider. And it's clear from the contract that the term building is defined specifically, but the term superstructure does not appear in the contract. Does that in any way undermine your position?
I don't think so, Your Honor, and here's why. One, yes, I agree that I actually don't contest the principle that the building, the superstructure can be distinguished from its foundation. But when we apply the text of this exclusion, none of those words are used. What is actually used is the fact that there must be, one, an ensuing loss or damage, two, caused by a peril that's not specifically otherwise excluded. So even if these can be distinguished as separate pieces of property, those three elements necessary to apply this exclusion have not been satisfied. In fact, when you look at the Bethany Boardwalk case, you see kind of the problem that arises when you try to draw this distinction, because smart attorneys can always find a way to, minimize the faulty workmanship portion of it. So when Bethany Boardwalk was decided, the gist of the summary judgment opinion in that case was the roof was defectively constructed, but the interior water damage caused by rain and wind and the storm were not. Now, after the insured basically lost that case, they filed a motion for reconsideration. What they did was they went back to Judge Hollander and they said, hey, actually the entire roof wasn't defectively constructed, only a portion of it is. So we still want the insurer to pay for the portion of the roof we still want the insurer to pay for the portion of the roof that wasn't defectively constructed. And if we buy into this line of analysis presented by Joe White, we're going to get into these disputes that have nothing to do with the text of the policy, but we're going to say, now it's not the entire foundation that was defectively constructed. It was only one half of it, or it was only a few cinder blocks, or it wasn't the construction of the foundation at all. It was the architect who designed it. And so if we start going down this road of analysis, we're going to lose the fidelity to the text of the policy, and we're going to get into this hair splitting of what the loss actually is. And before I move on, before I conclude, I do want to address the settlement exclusion. And quite frankly, if we were to adopt Joe White's position in this case, I don't understand when, if ever, the settlement exclusion would apply. The text of the exclusion says that it does not apply to loss or damage caused by or resulting from settling, cracking, shrinking, bulging, expansion of land, paved or concrete surface, foundations, pools, buildings, or other structures. Now, I fully respect the idea of the ensuing loss clause. As I've indicated before, I've argued that position many times. In fact, Judge Grimm just issued an opinion last week in Hamilton Jewelry where he again relied on Hartford Steamboiler for the proposition that doctrine does exist. So I'm not contesting that the efficient proximate cause rule is a thing that exists. But what we need to keep in mind is that these rules are analytical devices that we are using to determine what the parties agree to and what their contract says. So here, when we look and we see that the ensuing loss exclusion only applies if we can identify a, quote, peril not otherwise excluded, the efficient proximate cause rule cannot mean that only one exclusion applies and none others can, because one exclusion by its very text incorporates others. So all these rules have to take a back seat to the text of the policy that the parties agreed to. And that's the point. That's all the points that I've prepared in the last 2 minutes, Your Honors. I'd be happy to field any other question, but I think I've articulated my prepared points and I've addressed on the briefs.
Thank you, Counsel. Judge Rushing, Judge Alston, any other questions for Mr. Green?
No.
No.
Okay, thank you. We'll hear from Mr. Oring. I think you have 5 minutes.
Thank you, Your Honor. Let me, if I can, address some of the points that my colleague just raised. He cited selective way and the language in selective way that the damage in that case was a step removed from the faulty workmanship and was not directly caused by. What he was addressing was the damage that was claimed in Kearney, which was a case he discussed, for repair of the very property that was damaged by the faulty workmanship. And the quote is, plainly the damage claimed in Kearney was for repair of the property directly damaged by faulty workmanship. In the instant case, no claim has been made for repair of the faulty fitting on the water cooler line. Rather, the claim is for the water damage resulting from the failure of the faulty installed fitting. Thus, the damage is a step removed from the faulty workmanship and not directly caused by it. And the point is that, as in Sprague, which Mr. Green was about to mention, you can't recover for property that is the result or the damage caused by the faulty workmanship. And that's what the distinction was being made in selective way by Judge Berdar. I also want to mention Mr. Green's reference to the inextricably intertwined language that he said Judge Hollander used in Bethany Boardwalk. What Judge Hollander was referring to was the insured's claim in that case that the roof, which was defectively constructed, was covered because the damage was caused by wind damage. So therefore, the insured was making a claim to recover for the defective property itself. And what Judge Hollander said is that the roof, that the wind damage and the defective construction of the roof are inextricably intertwined, and therefore the defective property itself is not covered, which is clearly different from what we are talking about here. I also want to point out that Mr. Green indicated that Bethany Boardwalk stood for the proposition that an independent destructive force is required for ensuing loss. And I will say that that is turning that case on its head. Judge Hollander stated in Bethany Boardwalk that Maryland does not require an independent destructive force. It does not require attenuation. It requires three things. One, that the ensuing loss be a covered peril. Two, that it be the cause of the damage in question. And three, that it be the property that is separate and apart from the defective property. And I think that we have met all three of those elements. Collapse is a covered peril. The collapse was both the peril and the cause of the damage, and it was to property that is separate and apart from the defective property because the superstructure is distinguished from the foundation of the building by the policy. I also want to say a few words, if I can, about the TMW opinion. The TMW opinion is a Sixth Circuit case that arose from Michigan, which does adopt the consensus approach to ensuing loss. It requires attenuation. And the import of that opinion is that the language in the exclusion that refers to the cost of making good does not refer to the cost of making good what is in the exclusion, but it refers to the exception to the exclusion, which talks about the ensuing loss. And to me, I think the dissent had a much stronger argument that the reference to cost of making good in the exclusion talks about the cost of making good to the property that has been excluded. So that the language is that this exclusion does not apply to the cost of making good, and I'm looking for the exact wording of the exclusion. This insurance does not apply to loss or damage, including the cost of correcting or making good caused by or resulting from any faulty, inadequate, or defective, and then it goes on to say. And clearly, the language cost of correcting and making good applies to the exclusion itself. It doesn't apply to the ensuing loss. And I think that it would violate fundamental principles of Maryland law regarding the construction of insurance contracts to read that into the ensuing loss provision. Exclusions are to be read strictly in favor of coverage, and you can't, an exclusion by implication is not appropriate. And here, I think that's what the court is doing in TMW to make the ruling is consistent with the law from the consensus view.
Thank you, counsel. Your time's up, and we very much appreciate your arguments to both of you. As you know, we typically, if we were in person, our tradition is to come down and greet you and shake your hand and thank you for your work. We're not able to do that in this virtual setting. but that does not mean we don't appreciate y'all's fine arguments and your fine briefing. Thank you very much. We'll now stand adjourned from court and come back for the other cases later. Thank you.
Thank you, Your Honor.
This honorable court will take a brief recess. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Do we have one attorney on the phone, but no picture?
No, we have both attorneys on video. One is Jeremy Greenberg, who will be arguing first. And then also we have Lisa Arnquist on by video, and she's muted.
Okay, I don't see her at all, but she's going to come on soon.
Judge, I wonder if you're in speaker view instead of gallery view. Do you see a view button at the top?
Yes, but yes.
Does it say speaker? Is it checked for speaker or gallery?
Well, I don't know what I can't see that far. Speaker or gallery? Well, I switched it.
It should be in gallery view. Can you see Ms. Arnquist now?
No.
Can you see the timer?
You want me to reopen?
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Good morning. Thank you very much for your patience. We're happy to hear argument in Holloway versus State of Maryland. I'm Diana Motz, and I'm sitting with the Parabon is right there, and our newest judge, Judge Rushing, right there. I think she's still our newest. Has anything happened this summer? So we're happy to hear argument. Counsel?
Thank you, Your Honor. Jeremy Greenberg for Appellant Charles Holloway. Reserve 5 minutes for rebuttal. And may it please the court. This appeal involves 4 errors of law made by the district court. First, the district court erred by applying the evidentiary standard to summary judgment rather than the pleading standards required under Federal Rule of Civil Procedure 8. Second, the district court failed to accept Mr. Holloway's allegations as true and failed to provide him with all inferences in his favor when evaluating the sufficiency of his complaint. Third, the district court erred by finding that Mr. Holloway failed to plead sufficient facts to demonstrate claims of race discrimination and retaliation. Fourth, the district court erred by dismissing Mr. Holloway's complaint with prejudice without giving him the opportunity to amend to cure any supposed deficiencies or stating why amendment would be futile. For these reasons, the court should reverse the dismissal of Mr. Holloway's complaint and remand the case back to the district court so that the parties may engage in discovery to substantiate appellant's allegations. Despite paying lip service to this court's repeated instructions that a complaint is reviewed under Rule 12b6 motion only for the sufficiency of whether it states a claim of relief, the district court analysis of appellant's claims clearly demonstrates that it improperly applied the McDonnell-Douglas evidentiary standard of review at summary judgment. Throughout the opinion, District Court Judge Bennett imposed on appellant the burden of establishing evidence and a record in support of the prima facie elements of his claims. And that's at pages 42 and 43 of the joint appendix. Establishing evidence and a record is what a party does at summary judgment, not in drafting the complaint. Instead, as this court has repeatedly held, the district court should have reviewed the complaint to determine simply whether factual allegations that rise a right of relief to each of his claims above a speculative level, which it does. Before I move on to the specific claims of this case, I want to bring to the panel's attention an unpublished decision by this court on June 24th of this year in Hood Wilson v. Community College of Baltimore City. That's 850 Federal Appendix 844. In that decision, the court reversed Judge Bennett's dismissal of an employment discrimination claim where his analysis of the allegations in that complaint was remarkably similar in this case. There, the court held that Judge Bennett erred by requiring the plaintiff to plead the prima facie elements of her claims, erred by disregarding the plaintiff's own statements about her qualifications, and erred by failing to consider the pled allegations intended to show pretext. The court now...
If we agree with you that some of the analysis was based on the summary judgment standard, and we applied the correct 12b6 standard and came to the same conclusion, would there be grounds for reversal?
Your Honor, I believe that based on the review of the complaint, the court would not, in applying the appropriate 12b6 standard, the court would not find the same.
I do understand this is a hypothetical. If we should find that applying the 12b6 standard would come to the same result, we would have to affirm, right? At least those
Your Honor,
claims in which we agreed with the holding of the district court, if not the analysis.
Yes, Your Honor, the court would be able to dismiss the claims. However, I believe that because the appellant had not been given the opportunity to amend his claims to cure any of the deficiencies identified by district court, or if this panel agrees with any of the analysis of district court, that he be given the opportunity to amend his pleading to cure those supposed deficiencies, since he was not given the opportunity to do so below, and it was not discussed by the judge why it would be futile if appellant had amended his claim.
Well, can you forecast for me any additions that a complaint would have that would render it valid on any of the claims?
Well, Your Honor, I
Can you
believe
give me the opportunity to amend? Sorry.
Sure. Well, Your Honor, as I said before, I believe the allegations themselves are sufficient. However, in amending the complaint, I think it could be cleaned up to sort of differentiate the claims at issue. For example, there's the pay discrimination claim, which complainant has combined in his count one of his complaint, which I believe can be separated into separate cause of action. Additionally, there are other facts that I think that can be more streamlined to help the reviewing judge to more easily read the claims that and differentiate the claims at issue.
Counsel, I'd like to focus on your hostile work environment claim, which is a claim that seems like your client would have most of the information about without discovery. I recognize there could be some things beyond your client's experience that might potentially arise, but your client should, I would think, know that from his experience. This is a racial discrimination claim, and the allegations, none of the allegations you raise mention any racial slurs or racial language. And I'm not aware of a case that finds either hostile work environment or facts that support it, where there's not anything about the status, be it gender, be it race, that are in the allegations. I know there are a lot of cases out there on hostile work environment, but this seems to fall short of all of them that I saw. What do you think is the best case that helps you in that claim?
Well, Your Honor, first off, the appellant's claims of hostile work environment are both hostile work environment because of his race, as well as hostile work environment because he engaged in protected activities. Regarding, going back to Judge Motz's earlier question, in amending the complaint, that would be clarified. As it relates to Your Honor's question, that in the complaint itself, it does describe how in this hostile work environment that Mr. Holloway is being treated differently than others in regards to his race that do not, for example, as it relates to his treatment by Mr. Pendell, he is not being treated the same way as him in regards to how his interactions between him, that Mr. Pendell's undermined his leadership when he's not doing that too.
Sure. Yeah, I don't mean to cut you off, but I appreciate those allegations and see how they relate to your discrimination claim. But the law for a hostile work environment, really has a much higher bar under our law. And if there's one case you think that's most helpful to you on that claim, what would it be?
Well, Your Honor, I believe that, first to answer your question, I believe the Parker versus Rima decision, I think, is probably the most on point. And secondly, I would disagree with Your Honor's statement that as relates to pleading a hostile work environment claim that has any higher standard than any other claims under Title VII.
I didn't mean to suggest the pleading standard itself was higher. I meant but you still have to plead a plausible claim, but based on the legal standard for the cause of action. So anyway, okay, I appreciate you identifying that case.
Thank you, Your Honor. And as the court in the Parker versus Rima decision itself described, and reviewing those facts alleged, that all inferences must be reasonably taken from the allegations, including the overall facts that are alleged to the entire mosaic of the facts that are alleged. And those circumstances, specifically as identified in the Parker decision, including whether or not there was any physically threatening or humiliating conduct, and whether what was being alleged unreasonably interfered with the employee's work performance, and whether or not the facts or the harassment alleged was occupying or preoccupying the employee or management or coworkers. All those facts taken together are enough to substantiate a claim of hostile work environment. In this case, Mr. Holloway's allegations describe how he was treated differently than Mr. Pindell, and then that harassment and different treatment very much escalated after he engaged in protected activity. So much so that management's conduct negatively impacted his ability to do his job and his work with his subordinates, publicly humiliated Mr. Holloway on at least one occasion. He's alleged repeated beratements, threats of adverse actions, and then a violent outburst by his direct supervisor, where in that outburst he directly references his participation in the EEO complaint process. In addition, Your Honor, I'd also like to briefly discuss that discuss the identification of pretext that that appellant has identified in his complaint, that despite expressly describing why the stated reasons for his termination were pretextual, that Judge Bennett in his decision improperly found that to be actually dispositive, going in favor of Maryland rather than Mr. Holloway, by holding that despite Mr. Holloway perceiving his work as satisfactory, that it's the actual perception of management that is relevant to evaluating the sufficiency of Mr. Holloway's claim. And in that part of his decision, a district court relies on the case of Evans versus Technology Application, which is a decision from the circuit from 1996. First, as the district court repeatedly does throughout his opinion, Evans versus Technology was a review of a summary judgment decision, and thus inapplicable to a 12b6 motion. Second, by relying on the stated perception of Mr. Holloway's supervisors regarding his performance, rather than Mr. Holloway's specific allegations regarding what his performance actually was, the district court inherently created a factual inference contrary to appellant's allegations that he was a top performer and regularly received outstanding evaluations from when he was hired through the year of his termination. Moreover, a fact finder's evaluation of an employer's supposed perception is a determination appropriate for summary judgment or trial, not an evaluation of a complaint. Third, as the court held in Woods versus City of Greensboro, where a plaintiff's complaint includes a defendant's stated reasons for its conduct, quote, the question is not whether or not there are more likely explanations for the defendant's action, but whether the defendant's proper reason is so obviously an irrefutably sound and unambiguously non-discriminatory, non-pretextual explanation that it renders the plaintiff's claim of pretext implausible. In this case, Maryland's proper reasons for the termination are not so irrefutably sound and unambiguously non-discriminatory or non-retaliatory to render Mr. Holloway's claims implausible. Moreover, while not required to do so, Mr. Holloway's complaint also contains allegations that his supervisor's stated reasons for criticizing his job performance and Maryland's ultimate reason for terminating his employment are pretextual. First, after years of positive evaluations, Mr. Holloway began only to negatively be evaluated after engaging in protected activity. Second, one of the stated reasons for Mr. Holloway's termination was supposed budget mismanagement or budgetary issues, even though that was not the function, that was not one of Mr. Holloway's job duties. Instead, that was the duties of Budget Officer Nickerson, who was a Caucasian individual, and he has not been disciplined or otherwise counsel for these supposed budgetary issues. Additionally, the supposed budget issues that were allegedly justifying his termination were identified in April 2018, 4 months before Mr. Holloway's termination. Maryland's decision to wait 4 months in taking action on these alleged budget issues only after Mr. Holloway's May 28th, 2020 EO complaint is further indicative of pretext. Additionally, Mr. Holloway also supposedly was terminated for low enrollment numbers, but his Caucasian predecessor, Mr. Rose, was not terminated and instead simply reassigned after multiple years of low enrollment numbers. I see that my time is about to expire, but if your honors have any further questions, I'm happy to answer them either now or in my rebuttal time period. Thank you.
Thank you very much. Counsel.
Thank you. May it please the court. While a Title VII plaintiff does not need to meet the prima facie evidentiary standard, in order to survive a motion to dismiss, the plaintiff must satisfy the elements of a Title VII case and must meet the pleading standards set forth in Twombly and Iqbal, which requires that the plaintiff set forth facts that would establish a plausible entitlement to relief, as opposed to a possible entitlement or one that is based solely upon speculation.
But counsel, you would agree, wouldn't you, that the summary judgment standard is different than the 12b6 standard?
Yes, but I do not agree.
Then can I ask you why you cited so many summary judgment cases, leading the district court to also cite so many summary judgment cases?
Oh, I cited, in order to analyze whether a plausible case has been alleged, obviously the court has to look to what facts need to be proved in the case. And I don't agree that Judge Bennett applied the incorrect standard, because if you read his decision—
No, that wasn't the question I asked you. I asked you why you relied on these summary judgment cases. There are plenty of 12b6 cases. There are plenty of race discrimination cases in this circuit and around the country. And it just muddies the record for us and for Judge Bennett. And you do it in the court too.
I think that I cited cases that I think are informative or instructive on the question that's before the court. I think this case is controlled by the McCleary-Evans decision. Whether or not this plaintiff has alleged facts supporting a plausible inference that the actions he complains of were based on his race is, according to the Fourth Circuit, it's a context-specific task that requires the court to draw on its judicial experience and common sense. And when you look at the facts that are alleged, they do not support an inference that this plaintiff has alleged a plausible claim that he's the victim of race discrimination. The facts is alleged.
So, counsel, let me follow up on that. The district court talked about the pleadings referencing his performance and that those were his views and not the supervisor's. But as I read the complaint, it looks like he's alleging that he performed adequately based on evaluations from his supervisors. So it seemed to me it was not his subjective view of his performance as much as it was him reporting the evaluations that he received from his employer. On that issue, doesn't he plead that his employer gave him positive evaluations?
Your Honor, he pleads that he was employed from 2014 to 2018. And yes, the first employment evaluations and in the first years, and actually most of the years that he worked for the Free State Academy, were positive. But telling is that the one that he got in the year prior to his termination was negative. So if we were standing here in a situation where the plaintiff could allege facts such as, I have never received a negative performance evaluation, I was employee of the year, those are facts from which would support the argument that there could be an inference of discrimination. But we don't have that here. We have a plaintiff who's alleging that in the year prior to his termination, he got a negative performance evaluation from his supervisors.
But counsel, if I could just follow up on Judge Quattlebaum's question, you can also make the argument that he's saying that the assessment in the most recent year was discriminatory because he had good ratings. And I thought I read the district court opinion and perhaps your brief as suggesting that he was pleading that he was not a competent employee. All he is doing is reporting in his pleadings what his employer decided in the last year, which he disagreed with.
Right, because it goes back to—
And pointed to the earlier assessments, which he said were honest.
Well, it goes to the Iqbal Twombly standard. He has to plead facts that he pleads. I'm an employee. I received a bad evaluation. I was repeatedly counseled that my employer was not satisfied with my performance evaluation. And then he pleads, these are because of race. There's no facts that are pled that would support the filling of the gap of, okay, we have this set of facts that bring to mind the obvious alternative explanation that the agency was not satisfied with his performance. And we have him saying, we want you to make an inference that that's racial discrimination, but there's no facts to bridge that gap. That's basically—
Counsel, why wouldn't, I think you're right. I mean, I appreciate the Iqbal standard, I mean, in that regard, but why is not his allegations that the reasons given to him for his substandard performance and ultimately termination were pretextual? And because he gave reasons for that. He said that the enrollment and the budgets were not his job. You know, he said that Caucasian employees were treated different from him in regard to some of those issues. Those may or may not be true. He may or may not have had a part of his responsibility, the enrollment and the budgetary issues, but he at least seems to allege that the negative reasons given to him were pretextual, with some facts in the complaint. So I'm worried a little bit that that we're going beyond the allegation standard here.
Well, in response to that, I would refer the court to the decision in King versus Rumsfeld, because effectively the standard that we're here on now at the pleading stage is, has he asserted a plausible claim of discrimination governed by the McCleary-Evans case, the Bing case, which just recently came down, in contrast to the Woods case in which the court said that he did. And if he succeeds in stating the plausible claim, then he must move forward to the next step and either produce prima facie claim or direct evidence. The issue of pretext doesn't even become an issue until he meets that second hurdle of establishing a prima facie case. The burden shifts to the defendant to be able to say, this is our non-discriminatory reason, and then the burden goes back to the plaintiff to establish pretext. So what's happening here is almost the plaintiff is saying, oh, you're applying the wrong standard at the motion to dismiss phase, you're applying the prima facie standard, but then he himself is asking the court to apply the pretext standard. This case is governed by the holding in McCleary-Evans. It's further illuminated by the holding in Woods. It's further illuminated by the recent holding in Bribo. Simply put, do the facts alleged support an inference that is plausible, not possible, and not based on speculation, that the reason this individual was removed was because of his race? He was hired to replace a white program director. Okay, that doesn't support an inference of race discrimination. the white program director was removed from the same position for cause. That doesn't support an inference of race discrimination. His employer, for some time, for the entire year of 2018, was unhappy with his performance. That's what he alleges. And then he alleges, but in very conclusory fashion, and that was because of my race. And that's where you're talking about speculation being called in to fill the gaps. Because what fact is offered that supports the conclusion that the termination wasn't because of these other issues that are asserted by yourself in the complaint, that that you got a bad evaluation, they were not satisfied with your leadership, they had concerns about where you were during the day, they initiated a climate survey to ensure that the staff have feelings about management. You're supposed to look past all of that, and with no fact to support it.
Reasons, the climate survey, the inquiry about his location, and then even the ground were imposed on him that weren't imposed on white employees, so I grant you there's no direct, or there's no specific reference where someone said something that it was racially motivated, but this is a question, is imposing requirements such as a climate survey, such as a location inquiry, on and for someone who points to evidence that they are performing well, is that not facts from which we could infer discrimination?
Well, I'd say no, because the court has spoken about what type of comparators are sufficient to state a claim of discrimination.
Well, can I follow up on that? If the complaint at its moment does not allege that, couldn't he have added information to the complaint if he had been permitted to amend? I mean, usually we do let people amend complaints.
He never, Your Honor, obviously.
You don't have to ask.
But he never
for permission to amend. Ma'am, wouldn't you agree with that? Is it your position that you always have to ask for permission to amend?
Your Honor, respectfully, I think
Counsel?
in this case, when we filed the motion
to dismiss, is it your position that you have to?
No, it's not my position that you have to request leave to amend, but it is my position that having failed to proffer any facts, signal any additional facts, request or signal that you would amend, move for leave to amend after the decision, and frankly, Your Honor, here today, you graciously asked Mr. Greenberg to proffer any additional facts, and there were no facts.
Well, that may be so, but he's foreclosed. I mean, I would think it would be to your advantage to get out the whole case.
Well, I mean, in response to the standard for denying a leave to amend is abuse of discretion.
Well, we don't have motion to amend, so we don't know what that standard's not applicable here.
And I would just say that, well, I distinguished the case that Mr. Greenberg relied on in his reply because it was a case in which it was a pro se plaintiff, and that plaintiff had signaled to the court before the final decision was issued that he wanted to amend his complaint.
That's true. The case relies on our pro se plaintiffs, but our court has, in recent years, pulled back from any favoritism we gave to pro se plaintiffs. So I'm not sure that is a fact. I'm not sure it distinguishes this case.
But in the Bravo decision, the court was also gracious, and that was a plaintiff who was pro se. The court also, from my reading of the decision, asked is there any additional facts that you would be able to allege? And similar to this colloquy today, there were no facts that were put forth that would change this analysis in any way. So I don't think Judge Bennett erred in exercising his discretion when a plaintiff is silent, especially, for instance, on the pay discrimination issue. It was a facts that were alleged in this complaint in support of the retaliation claim and the hostile work environment claim.
Can I ask you one final question about the retaliation claim? There, all you need is a good faith belief in discrimination. Surely this complaint demonstrates that.
I'm not sure I understand.
Good faith belief. That's what our case law says over and over again.
I just think I think Judge Bennett was correct. He's not able to allege facts that would establish a plausible claim of causation.
Well, he certainly alleged enough to show his good faith belief that he had been discriminated against when they fired him after he made these complaints.
But he has to
retaliated against it.
But he has to show that he engaged in opposition activity. Yes.
Well, filing these complaints, wouldn't you regard that as activity?
Yes, Your Honor.
Okay, so he's done that.
That's conceded. He has to establish that he suffered an adverse employment action.
Well, he alleges that. That may not be true, but that's what he alleges.
Yes, for purposes of the motion, yes. But then he's got to establish facts upon which the court could conclude that there was causation between the two. And the judge cited, and Judge Bennett citing the case law correctly found there was no facts that would support a finding of causation. And the causation standard is strict.
Good faith belief. I just don't really understand the retaliation argument that you're making.
Well, I mean, in order to plead a claim of retaliation under Title VII, the plaintiff must establish, one, that he engaged in opposition activity under Title VII, and for purposes
he has. We agree. He did that.
We concede that for purposes of the motion. That he suffered an adverse action, something that would deter an individual from filing complaints. He says he was terminated for purposes of the motion. We agree. That could be an adverse employment action. But the third is the difficult one, and that's to establish that there was that his opposition activity was the reason he was let go. And so he has no direct evidence. As Judge Quattlebaum pointed out, this is not a case where he can say anybody mentioned his race. He was hired for this job by the same
counsel. Can you help me with the facts that he has pled to try to establish causation, at least at the motion to dismiss stage? The district court pointed to the timing, and I understand the district court said that it was not close enough. But in that gap, and the timing gap that the district court talked about, plaintiff has alleged that he had this meeting with Teller, who yelled and banged the table and specifically said, "I'm aware of your complaints, your grievances, and I'm going to be involved." Why is that not sufficient to bridge the causal gap there at the plausible pleading stage?
Well, that fact, it's a moving target at this phase. That fact was offered in support of the hostile work environment claim, not the retaliation claim. But
how do you know that? That's in his complaint. It's in his complaint. I have to read all of the allegations of his complaint. I'm not allowed to pick and choose which ones I believe for which cause of action.
I mean, to say that he was fired or he was retaliated against when he sought a meeting with his superior. He asked Mr. Teller if they could meet, and Mr. Teller scheduled the meeting. Mr. Holloway objected to the fact that it was earlier than he usually comes in, and then they had this conversation in which it's a moving target. He first says he slammed the paper on the table. Now in the briefs, he slammed objects around. I mean, it's not, in my opinion, I don't know of any case that that's held in this circuit or otherwise, that a meeting between a supervisor and a subordinate that was asked for.
I guess, counsel, my question is just, even we have cases where we have this time gap and we're trying to figure out, is that sufficient to suggest causation at this stage, this early stage? But we have cases where we say, well, we have a time gap that's a little, it's getting on the long end, but we have this additional fact that has been pled. And I'm wondering if this additional fact in the interim is sufficient here.
I would say affirmatively no, because it's not, the meeting itself isn't something that would be characterized as an act of retaliation. The way I read the case law, and certainly I'm not the expert, is that if you have no direct evidence of supporting retaliation, the kind of evidence that Judge Quattlebaum, usually you see in these types of cases, then you can still survive the motion to dismiss if you can do it on temporal proximity. And so he was really, that's all he had, and really that's all he argued was the temporal proximity. But in this case, it's interesting because his first complaint of discrimination was 6 months before. So the way that the court interpreted the facts was conservative in favor of the plaintiff, and said, instead of saying, well, if you're alleging that you were fired for making a complaint of discrimination, you made one in February of 2018, you weren't fired until August. The court still said, even considering the subsequent ones, which again, to me, even considering the last one, it's still 3 months, which is too much time to infer that you've stated a claim of retaliation.
Counsel, your time expired. Unless one of my colleagues has another question, I ask you to summarize and cease.
Thank you. I would, I'm happy to submit on my papers if there's any question I'd be happy to answer.
Thank you very much.
Thank you.
Is there any rebuttal?
Yes, Your Honor.
Thank you.
Thank you. Your Honor, I would just like to address a few points. First, to clarify the factual record I alleged in the complaint, I believe my opposing counsel stated that Mr. Holloway's predecessor was terminated for cause. That is not a complaint that was alleged in the complaint. Instead, what is specifically alleged is that in lieu of being terminated, that Mr. Holloway's predecessor, Mr. Rose, he was in fact given another position and transferred. Secondly, another point is that during Ms. Arnquist's argument, she very much relied on the case of King versus Rumsfeld to try to bolster the points. However, yet again, as Judge Motz noted earlier, that is yet another summary judgment review decision. So again, the state of Maryland is repeatedly trying to have the court review the pleadings of this case based on summary judgment standards review, where there are a factual record that a court or a jury can later review.
But counsel, on that point, I think it's fair that if you cite a summary judgment case at a 12B6 standard, we need to be really careful that we're looking at it not applying the wrong standard. But summary judgment cases that state the law can inform what facts must be plausibly pled. So I think it. I don't think the fact that a case is a summary judgment case automatically means we can't consider it if it helps us inform the law. The problem we get in is if we mix or match the standards and aren't real clear with what we're doing. Would you agree with that?
I absolutely would agree with that, Your Honor. And I think that is exactly what Judge Bennett did below, where he is mixing the standards despite paying lip service to the 12B6 in his standard review section of his opinion.
So for example, on your hostile work environment claim, if we look at the cases that talk about that, the 12B6 cases and the summary judgment cases that impose a level of conduct that is more than discriminatory. It's got to be so intolerable that you're essentially constructively terminated. You then have to plead facts that satisfy that standard, correct?
Well, Your Honor, I would disagree with your summary of what the standard is to establishing a hostile work environment. It doesn't have to be so intolerable that it causes you to resign. It just has to be for race discrimination to be severe, pervasive, to affect your terms and conditions of your employment, and for a retaliation claim that it reasonably dissuade an employee from engaging in protected activity. But I would agree that the court can look to cases just to describe the elements of those claims, but make sure that they are applying the proper standard of 12B6, particularly in a hostile work environment claim, where this court has repeatedly instructed reviewing court or lower courts that they must view the totality of the circumstances alleged with all inferences in an employee's favor, and particularly where the conduct is such that there's allegations of public humiliation, threats, and even just particularly when it's done by a supervisor, which I believe were led in this case. And just to address the causal connection discussion that was addressed at the end tail of the last discussion. First off, as it relates to the temporal proximity issue, as it relates to a reviewing motion to dismiss, this court has found that just that 3-4 months is sufficient at the motion to dismiss stage to state a claim of retaliation. At summary judgment, a complainant or a plaintiff will need to show more beyond mere temporal proximity to establish those claims. However, at a reviewing the pleadings, this court has approved of 3 and 4 months gap in time. In addition to that gap in time, though, in this case, the complaint does also discuss Mr. Teller's express comments describing the impact that the EEO complaint will have on himself, and thus reference it during the interim between Mr. Holloway's last complaint and the termination, as well as pleading those facts that demonstrate pretext, and thus, with all inferences in his favor, that the real reason for his termination was not as stated, but in fact was retaliatory or discriminatory. And I see that my time is up.
Thank you very much for your argument. We appreciate it from both of you. We will take the case under consideration. We're going to argue in our next case. Next case, Herrera Martinez versus Garland, number 2014-23. Counsel?
Thank you, Your Honor. You may please report. My name is Crystal Swensbo. On behalf of appellant, Mr. Walter Herrera Martinez, I have reserved 5 minutes for rebuttal today. Your Honors, Mr. Herrera Martinez is entitled to the holding of removal as a member of a particular social group of prosecution witnesses. Specifically, the witness who reported harassment to the police was made public by the Honduran police and then targeted with threats and violence by narco traffickers as a result of his report.
Sorry, counsel, was that's not the PSG you described in your brief. Could you point me to where that definition is in your brief?
Your Honor, we discussed it, I believe, as the second issue presented in the brief. We use the term prosecution witnesses as kind of an overarching term. Certainly this is what was used in the Ninth Circuit. I believe the Fourth Circuit has spoken about it. But in each of those cases, the court has required a bit more detail in terms of defining the particularized social group. which is what I'm attempting to do here.
Right. So on page 21 of your brief, you define prosecution witness as Honduran citizens who make reports to the police about the unlawful activities of narco traffickers to facilitate prosecution. That's my understanding of your definition of prosecution witness. Is that correct?
Yes, Your Honor.
Okay.
I apologize for any confusion. I'm simply tying into the facts of the case as well as the persecution point, which is on appeal.
I can't hear you very well. It's sort of muted.
I apologize.
Can you do anything about that?
I can attempt another microphone. I will try that right now. If not, I will simply try to speak a bit louder.
Okay.
Thank you. With respect to
Judge Quattlebaum, did you have a question as well? No.
No, I'm good for right now. Thank you.
Okay.
Your Honors, in addition to the withholding of removal claim, Mr. Herrera Martinez is also entitled to protection under the Convention Against Torture, or CAT, for several different reasons, which I'm happy to get into in a little bit. But first, with respect to the withholding of removal claim, we would note as an overarching point, the government has forfeited any opposition to withholding of removal by failing to address it on appeal. Mr. Herrera Martinez, in this case, is part of the particularized social group, as Judge Rushing has mentioned. With specific facts here, witnesses who report the harassment by narco traffickers aid the police. And in this case, Mr. Herrera Martinez was made public by the police.
I'm still having trouble hearing you.
Yes,
so, and I think this is an important issue. And when you get back to us, I think the government's position must be, because your client was found not credible, we can't look at any of this other evidence about particular social group. So maybe you can, I think that's where they're going. I take it that you say that they forfeited the argument, but I think that they say since he's not credible, the judge didn't have to believe that, and therefore.
Your Honor, we do understand that the government mentioned credibility in their argument. However, the IJ and the board did not rely on credibility in determining the particularized social group here. The facts found by the IJ were not contrary to Mr. Herrera Martinez's testimony, and the IJ stated in the withholding decision that his ruling went beyond credibility. And further, this court has held that credibility is not determinative of a non-discretionary withholding of removal claim. That's from the Singh versus Holder case in 2012, where they affirmed the credibility ruling but went on to determine whether withholding of removal was nonetheless appropriate.
So, counsel, I want to go back to your particular social group and make sure I understand that. I thought you were claiming prosecution witnesses without more definition. And it sounds like you're saying something more that has more information now. Individuals who file complaints against narcos I may misstate it a little bit, but you don't seem to be talking about prosecution witnesses generally. First of all, is that correct?
Your Honor, we believe prosecution witnesses are an appropriate PSG as suggested by Fourth Circuit law, as well as the other circuits that have considered this question. However, to be specific to Mr. Herrera Martinez's position, we feel that we need to discuss the facts and how he fits within that particularized social group.
I'm sorry I just want to go step by step in this. So if you're claiming that prosecution witnesses generally are sufficient, of course, we have the author of the opinion, I think, on our panel that deals with a similar topic. But there was a strong emphasis. It was clear the witness had testified. You seem to be saying now prosecution witnesses can be someone who files a complaint as well. And so I'm trying to figure out if the group is prosecution witnesses or something else, because if it's prosecution witnesses, generally, it seems to me to raise questions about whether that means someone who's testified or someone who's filed a complaint or someone who's agreed to testify or someone who's identified someone in a lineup or countless other sort of ways, which seem to beg the question of who's in and who's out. And so it's important, to me at least, to understand what specifically your PSG is.
Certainly, Your Honor. The prosecution witnesses, and we use that term because that is what the Fourth Circuit has looked at, but in that there is a key kind of factual distinction between a witness who submits a secret complaint to the police versus one who is made public. We would argue that there's no distinction, no effective distinction between a witness who reports to the police and then is made public by the police, either by being compelled to testify or by being outed to the very tormentors that they are reporting about. And that's why we have, in this case, that factual nexus for Mr. Herrera-Martinez. Much like a prosecution witness, he went to the police, he filed a report, the IJ noted and the board adopted that the police then went and told the narco traffickers about that report. So he was brought into public light, much like a witness. A witness would be in a traditional prosecution.
Well, can I ask you? Sorry, go ahead.
No, go ahead, Judge Motz.
I was just going to ask you about this matter of HLSA BIA case. And they said, and the board said there, the BIA has held that cooperating with law enforcement in a public manner, particularly testifying in public proceedings, is sufficient to establish a valid social group if there is evidence that society in question recognizes and provides protection for such conduct. Okay, so it doesn't seem that testifying is necessary if you do this cooperation with law enforcement in a public manner. Now, I wasn't sure from your response to Judge Quattlebaum is your definition the same as the BIA's definition?
Your Honor, we would accept the BIA's definition in that point, but note that HLSA has several, I think, legal infirmities, particularly with discussion of the public aspect. The Third Circuit, the Seventh Circuit, the Second Circuit have not required the type of publicity that HLSA discusses. And we would, in fact, urge this court to look to the Third Circuit's opinion in Guzman or Arellano, where the individual submitted a report to the police and he was made public because individuals saw him speaking to the police in front of his own home. That was the level of publicity in Guzman. We certainly don't need that level of publicity here, as Mr. Herrera-Martinez was made public by the police, much like he would be in a traditional prosecution setting.
He didn't testify, is that right?
That's correct, Your Honor. There was no prosecution.
And he didn't publicly, there's no publicly knowing that he reported until the police made that public. Is that right?
Yes, Your Honor, that's correct. And that's what we would ask the court to adopt here. Your Honor, we would also note that the particularized social group in this case is socially distinct within society. We're going to Judge Mott's earlier question. It's regarded as distinct within Honduras because, as we noted in the record, I believe it was the UNHCR report, page 889, prosecution witnesses are specifically targeted for violence in Honduras, and Honduras has created a law to protect those witnesses.
Counsel, first of all, I don't think the board ever addressed social distinction. So it seems to me with withholding, and correct me if I'm wrong on where we are with that issue. The board found that it was not particular in its second opinion, and that was never addressed again. So if we're and the IJ didn't address withholding in its following opinion, and then the board didn't address that either. So it seems to me we need to assess the particularity issue And if we agree with the board, I suspect you lose on that. If we disagree, I think it seems like our option would be to send it back so the board can assess the issue of social distinction. Do you disagree with that?
Yes, Your Honor. The issue of a particularized social group and whether a proffered group is particularized sufficiently is a legal matter that this court reviews de novo. So the court need not remand in order to determine whether the group proffered is a particularized social group. Now, of course—
Agree. I'm talking about social distinction. I'm sorry.
Oh, Your Honor, I believe the social distinction point is also a legal determination, whether there was effectively an application of the standard to the information presented. This court certainly has the ability to look at that de novo as well. Your Honor, also considering in this case, we've discussed, I believe, 2 of the 3 elements. The third one is this immutability. Mr. Herrera-Martinez has a shared experience with other prosecution witnesses that cannot be undone. We would note that he also satisfies that element of the test for a particularized social group. And there is no question that there's a causation. Mr. Herrera-Martinez was targeted because of his report to the police, and the violence to himself, his family, and his friends came after the report. The narco traffickers told him they would kill him if he spoke to the police again. Your Honor, we also note that Mr. Herrera-Martinez suffered persecution. The IJ and the board misapplied the law in the Fourth Circuit to undervalue or disregard threats and violence suffered by Mr. Herrera-Martinez, his family, and friends. We also note that the IJ and the board erred by failing to consider pertinent evidence of future persecution. In this case, persecution can be demonstrated either by past persecution or a reasonable fear of future persecution. We note that the record includes threats to Mr. Herrera-Martinez's family, multiple affidavits detailing that, and these affidavits are not simply corroborative of Mr. Herrera-Martinez, although they are in some part, but they are first-hand testimony of the violence that was brought upon them as a result of Mr. Herrera-Martinez's report. That's why it's independent, separate evidence, and why the IJ and board erred in failing to address it.
Well, did they not address? Go ahead, Judge Motz. I'm sorry.
No, go ahead.
So did it seems to me what you're talking about now, the IJ actually addressed in its credibility analysis. It talked about a lot of those, affidavits and witness statements and how it found them, either inconsistent in some situations and uncredible or implausible in others. So maybe it was more in the credibility analysis, but doesn't the IJ's, I know you argue that was an unreasonable determination, but if we disagree with you on that based on the standard of review, didn't the judge address those issues in the credibility analysis?
Your Honor, I see I have about a minute remaining, so I will—
You can answer the question.
Thank you, Your Honor. No, Your Honor, the IJ and the board did not address this point of persecution in the second opinion dealing with credibility, largely because in that second opinion by the IJ and the board, the agencies were focused on the question of torture, which is related to the cat protection claim. They did not address persecution separately, although obviously much of the evidence is overlapping. The point about persecution and torture, there are separate legal standards, and the Fourth Circuit has found even the threat of death sufficient to find persecution, whereas evidence of torture requires a bit more under cat. And I'm happy to address any questions about the cat protection claim. Otherwise, I'm also happy to address any further questions on the rebuttal.
So I'm still, can you tell me what a social group was argued below? I know you weren't counsel.
Your Honor, I believe both in the IJ before the board, the particularized social group was that of prosecution witnesses. And then there was discussion of the other circuits and how that term has been used, including, I believe there was reference to I apologize if I'm not 100% on the timing, but the Third Circuit case, which noted that it did not necessarily have to be a witness in a prosecution at court. So that was what was argued below. And in finding that we would argue Mr. Herrera Martinez is part of that particularized social group, we believe the court needs to look at the specific facts applicable to him. That he reported to the police, that he was outed by the police, and then targeted as a result.
But he didn't testify. He was not a witness.
Correct, Your Honor. There was no.
You don't rely just on. Do you see where I'm going? One could still conclude that prosecution witnesses are a particular social group, and that your client did not fit within that group. But you're saying to me that it was argued to below, and the courts, the IJ and the board rejected the idea that prosecution witnesses were a particular social group. Is that what you're saying?
I believe so, Your Honor. The IJ and the board erred by finding that the proffered PSG was not sufficient as a particularized social group. But this court could certainly remand in order to determine, for the IJ or the board to determine whether Mr. Herrera Martinez fits within that legal category. And we certainly have additional evidence we would present beyond remand.
Okay. Any further questions from my colleagues? Okay. We're happy to hear from the government.
Good morning, Your Honors. Sarah Pergolesi for the government, and may it please the court. I'd like to start, again, as Judge Motz pointed out in questioning the petitioner, with the adverse credibility determination, which is dispositive in this case. Importantly, because as we acknowledged in our brief, an adverse credibility determination can be determinative in a withholding claim, provided there is not objective corroborating evidence that otherwise meets the applicant's burden of proof. And here in this case, the petitioner has failed to point to compelling record evidence, both that the adverse credibility determination is not supported and that the other objective record evidence in this case could otherwise rehabilitate his testimony or independently meet his burden of proof. And in this
counsel, can you help me kind of at the outset understand why this is not a Chenery problem? Your argument about credibility seems to be saying if petitioner's not credible, then there's no evidence that any of this happened, right? That he's a member of this PSG. There's no evidence he's a member of this group because we don't have reliable evidence that, he was actually threatened and went to police and all that. But the BIA didn't rule on the grounds that he's not a member. The BIA said prosecution witness, as it's been defined in front of the board, is not a particular social group because it's not particular. That's a different ground than the one you're advancing in front of us. And we're only allowed to review the ground that the agency ruled upon. So why is this not a Chenery problem for us?
Your Honor, I have two related responses to that question, which is a good one. First of all, that because this is a strange procedural case in that we have two immigration judge decisions and two board decisions, I would note that the through line does exist that there were credibility concerns, even in the immigration judge's original decision regarding withholding and CAT. The immigration judge noted in the decision at the outset of the withholding findings that she had credibility concerns. The board then, again, as you noted, absolutely affirmed the withholding merits decision, but also remanded so that the agency could consider, if necessary, the merits of CAT and also consider credibility. The immigration judge in their second decision incorporated all the findings from the original decision at the outset. And so we would argue that that incorporation also includes the credibility concerns, which are certainly relevant to the withholding claim as well as the CAT. And so relatedly, my second response is that even if the immigration judge was not clear that the adverse credibility covered the withholding claim as well, that remanding for consideration of the withholding claim would be futile in light of this credibility determination that is supported by substantial evidence.
Yeah, I get what you're saying, that credibility on these facts cuts across both issues, but this strikes me as different than the cases where we've said the board has already said how it would come out on a different issue, or its factual findings on one ultimately doom another. We can't put ourselves in place of the board and say, well, this is how it would have ruled if it had thought to have an alternative ruling. The board ruled on particularity. It didn't rule on whether he's a member of the PSG or not, and I'm not clear that we can just substitute any other, ground for denial that we think would fit.
I understand that concern, Your Honor. But I would point again to the extent of the immigration judge's adverse credibility determination, to the extent that with respect to Kat, the immigration judge, or explicitly with respect to Kat, the immigration judge had significant concerns about pretty much every aspect of the petitioner's claim that he was threatened and harmed, and also about the facts that he claimed informed his continued fear of returning to Honduras. And all of those things are certainly relative and arguably dispositive of his withholding claim as well as his Kat claim. But again, I understand your concern.
Why did you not brief the grounds for the board's decision?
At the outset, the adverse credibility seemed like is certainly a strong and supported decision.
You know what it looked to me like is that you agreed with that part, that you agreed with the appellant's argument about the particular social group. So you weren't ready to, as the United States, suggest that they were wrong. That's what it looks like.
I think most frankly, the particularity issue, especially in this circuit, has been in flux in the course of this briefing, right? Ayala had very recently come out and we were still grappling with how to deal with the court's new case law about how it would analyze particularity.
You don't have to, I'm not asking for your strategy. I don't mean to be, asking to peek behind the curtain. It perplexes me that the board ruled on one thing, one part of a 3-part test, and the government is not arguing that part. Now you're the appellee, and to respect the board, we should review what the board did. So I'm not ready to say that you could waive it or that you forfeited it, although you did. But we have to review what the board did, whether you bothered to brief it or not. But I just want to flag that, it's fine if you think credibility is a stronger argument, but I think it would behoove the United States to brief the grounds that were relied upon below when it knows that we are constrained to review those grounds.
I understand, Your Honor, completely, and that behoovement is taken very serious. I take it very seriously. But again, I would just stress that even at the stay stage, we made clear that our position was that this adverse credibility determination covers withholding and Kat, and that at least there is an arguable basis to find that the immigration judge in their second decision reincorporated the credibility concerns, and that at least the structure of the immigration judge's second decision is that credibility is addressed fully first, and then how credibility relates to the Kat finding is then addressed separately. And so at least, again, that there is an arguable path to say that this was covered withholding as well.
So counsel, understanding that position, moving to the issue that the board did rule on with respect to withholding, do you contest the decision that prosecution witnesses, the category argued below, was not particular?
No, we would also defend that decision, but I do acknowledge that we didn't brief it. But I would just note that I do disagree with petitioner's contention that social distinction is a legal question as well. It is very classically a factual question, as Judge Motz pointed out, whether the petitioner is a member of their proposed group. And so if this court were to disagree that adverse credibility covers the withholding, and regardless of what this court decides on particularity, then the continued cognizability of that proposed group would need to go back to the agency to make necessary fact finding with regard to those other factors.
Counsel, could you cite for me a case in which a court has given an adverse credibility holding the scope that you want us to give this one? I mean, I'd never seen this argument before in 20 some years of doing this.
I'm sorry, Your Honor.
Well, it's good to have novel arguments.
In my research, I certainly found cases where a decision was denied on credibility grounds alone. If you're asking about whether credibility can be dispositive of holding at all, just not regarding sort of the scope of what the agency found, then I did find cases saying that I cited in the brief. But also
you did find cases that did what? I didn't quite understand your answer.
Where the denial of credibility was controlling of withholding claim entirely. Or the finding that there was no credible, There was a particular social group claimed, and there were other claims. It wasn't credibility. I see what you're saying. I don't know. Right. I see what you're saying, and I'm not sure if I looked specifically for that question. And I see you roll your eyes. But what I'm trying to say is that often cases aren't decided on that many separate dispositive grounds. And so an adverse credibility determination is often determinative because it's the only finding found. But I see what you're saying.
Well, conversely, are you familiar with cases in which there's been an adverse credibility finding, and yet the board has gone on to discuss other things, and our opinions then discuss other things, like a particular social group?
Well, again, I didn't find a lot of those, but I would like to point to Ilunga as instructive of a case that is like that, and that I think is quite distinguishable from this case. The court, I can't remember if the court disagreed with the credibility determination explicitly, but they also noted that there was, direct, corroborative, objective evidence of past persecution that required remand. And the kinds of evidence that Ilunga did present are very unlike the kinds of corroborative evidence that Herrera presented in his case. Namely, Ilunga had a doctor's report from the US concluding that his injuries were consistent with his claim that he experienced torture. He had a membership card confirming his membership in a minority political party. And he submitted country conditions evidence that was objective and indicated that minority political parties were often targeted. In this case, aside from Herrera's testimony about his past experiences, he has letters from interested family members, as Judge Quattlebaum, I think, pointed out, that are not necessarily reliable and independently capable of meeting his burden of proof. And he has generalized country conditions evidence that gang violence is prevalent in Honduras and endemic across society. And so again, even addressing sort of the alternative merits of this case, there isn't sufficient evidence to support the petitioner's contentions that this social group is, as a matter of law, cognizable, or that the petitioner, even if the court were to agree about that, remand would be necessary for the agency to determine other elements that weren't addressed, such as nexus and the likelihood of future harm.
But the government isn't arguing that.
Right. I would also briefly like to address CAT, if the court will allow me. As we argued in our brief, again, the adverse credibility determination is certainly more explicitly applicable to the CAT finding. And the petitioner has failed to really point to a solid argument against the agency's finding that adverse credibility weighs heavily against his ability to meet his burden for CAT. It wasn't the sole determination that the agency rested the CAT denial on, but it certainly is something that is important if you can't tell what happened to someone, then it is very difficult to ascertain whether they face a particularized risk of torture, which is required under the regulations.
Counsel, if I could ask a question about the CAT issue, and particularly the final board decision. Is it the government's position that the IJ's analysis and findings concerning acquiescence and participation, or lack thereof, are incorporated and adopted by the board decision?
We argued both, but again, it would depend on how the court will agree with, whether the court agrees with our reading of the agency decisions. Essentially, again, there is that through line in the sense that the immigration judge in her second decision incorporated those alternative merits findings with respect to the CAT finding, and the board adopted the immigration judge's decisions, but didn't as explicitly adopt that portion. It addressed primarily the credibility and and then the related failure to meet the burden of proof independently. So that is our main argument, that finding is supported by substantial evidence.
Okay.
I don't think we have any further questions, do we?
Okay.
Thank you very much.
Thank you, Your Honors.
Have further argument?
I don't. Thank you, Your Honors.
Okay, do we have any rebuttal?
Yes, Your Honor, if I may. Your Honors, may it please the court, on rebuttal, I have 3 brief points. The first being that the credibility ruling is not determinative of withholding of removal. As I noted before, the Singh versus Holder case from this court, 2012, affirmed an adverse credibility ruling, but still went on to discuss whether there were other grounds for relief, which is what this court must do, we would argue in this case. Additionally, with respect to the particularization or the particularity point that the BIA addressed, we would ask the court to find, in accordance with, I believe, the Third Circuit, the Second Circuit, the Seventh Circuit, and as well as been suggested by Fourth Circuit opinions, that individuals who assist the police, whether it be by providing testimony, giving some type of report, and are then made public, should be protected as a particularized social group. They are sufficiently particular in that the kind of the second step of being made public helps delimit them in the public, or delimit them in the law.
So counsel, but how do we square that with the particular social group that you argued below? I get the argument that someone who files a statement and is made public could satisfy the particularity requirements. You're putting some limiting facts in there. And maybe Crispin is the answer, that it essentially has already decided it. Maybe it doesn't. There's been some discussion over that. But without you putting those other facts about being made public and about filing a complaint, I'm just having trouble understanding what prosecution witness, what's in and out as far as prosecution witnesses go.
Your Honor, respectfully, those facts were before the IJ and have been since the beginning. In fact, the IJ discussed with respect to Mr. Herrera-Martinez.
Sure.
And certainly the excuse me.
I'm sorry, but facts before the immigration judge is a different issue than what the particular social group is. And your client argued below that prosecution witnesses were a particular social group, and that may or may not be problematic, but it seems to me like you think it might be because you keep adding to it. And I'm sorry, go ahead.
No, I apologize. That is certainly not the impression I mean to give. We believe prosecution witnesses are an appropriate particularized social group, one that is supported by the law, and that this court can find with a de novo review of de novo review here.
And just to point out, your client defined prosecution witness for the board as Honduran citizens who make reports to the police about the unlawful activities of narco traffickers. So that's the PSG that we have to evaluate. We can't evaluate a new one that you are talking about on appeal in front of us. We have to evaluate what the BIA evaluated. So tell me why that particular social group is particular enough.
Your Honor, it's particular enough in the same sense that I believe it was Judge Floyd mentioned in his concurrence for Zelaya. To the extent that prosecution witnesses, individuals who make these reports and who are then called into court or made public in a sense.
But this group that you articulated in front of the board could include anonymous tipsters, folks who call in an anonymous tip on the phone to the police about narco traffickers and never made public.
Your Honor, with respect, the Seventh Circuit and the Second Circuit have found that similar circumstances are sufficient to make a particularized social group. We certainly don't need the court to find that here, as there was this publicity inherent, but that is enough under, as other circuits have found.
But not under the board's HLSA decision. They pointed out that a group that has all these indeterminacies, including anonymity, would not be particular.
Yes, Your Honor, that is what HLSA says. But as I mentioned before, we have some disagreement with HLSA. And
sure.
Obviously, we would be happy to address that on remand to the extent necessary. Your Honors, I see my time is about to expire, but I would also, in this brief time, like to point the court to the uncontradicted, firsthand, legally significant affidavits that the board and the IJ failed to consider. Happy to go into those in detail, but there were multiple that went into the witness's individual experience and not simply corroborative.
I'm sorry, what did this evidence do? I couldn't hear you.
I apologize, Your Honor. With respect to the evidence, it was independent. A large number of it was affidavits by Mr. Herrera Martinez's friends and family. It spoke not only to corroborate Mr. Herrera Martinez's experience, but also about their own experiences in being threatened by the narco traffickers. I point to the record, page 615, Mr. Wilmer Martinez. He gave information about how he was harmed and threatened with an AK-47 by the same narco traffickers that beat Mr. Herrera Martinez. Additionally, Mr. Herrera Martinez's former partner would argue she is independent as they are no longer together. She has no essentially dog in this fight. She wants as far away from Mr. Herrera Martinez as possible due to the threat he has brought to her and her children. With that,
can I go back to the particularized social group one more time? So you are arguing in front of us that there was publicity connected with what your client did, right?
Yes, Your Honor.
But you were saying that there need not be. Is that right? To have a particularized social group.
That's correct, based on the cases I've cited previously. With that, Your Honors, thank you for your time.
The argument that was made below was that this person was in a particularized social group. And what was that particularized social group that was argued below?
Your Honor, I apologize. I don't have the specific language. Judge Rushing has quoted it from page 21 of our brief, but it related to the reports made specifically to police. And then I believe there was targeting following the reporting.
I believe JA 131 has your brief to the BIA, if I'm looking at that correctly, but don't hold me to that.
I appreciate the reference. Thank you, Your Honor. As we noted, the publicity is certainly not required, especially under the Seventh Circuit and Second Circuit cases that we cited. But we believe even here we have more than that, which would allow Mr. Herrera Martinez to be part of a particularized social group. For those reasons, we ask the court to vacate the lower opinions, and then to remand if necessary, or to grant relief, and then to return Mr. Herrera Martinez to the United States for that proceeding. Thank you.
Thank you very much. Thank you, counsel, for your arguments. We'll go to our third case. All right, we're happy to hear argument in Cabrera versus Garland, number 20, 1943. Counsel, we're ready when you are.
Good morning, Your Honors, and may it please the court, Melody Duke on behalf of Representative Garcia Cabrera. The immigration judge and the BIA erred in their decisions to deny the petitioner's motion to continue in two ways. First, the immigration judge abused his discretionary powers when he failed to consider all of the good cause factors in their totality. Instead of applying a balancing test of relevant factors, the immigration judge cherry-picked the factors he felt would fit his already made-up mind. In turn, the BIA did the same. Second, the immigration judge violated the petitioner's Fifth Amendment due process rights by arbitrarily disregarding an immigration judge's instructions to set a new hearing date for June 2019 based on her pending U visa. Further, the immigration judge hurried the petitioner through the court system and ordered the petitioner removed after just one master calendar hearing in Charlotte. Her is from Mexico and has.
I can't hear you very well again. I don't know if it's me or what it is, but maybe your microphone is off or you're too close or too far away.
Okay, so I just adjusted it. Can you hear me a little bit better this time?
Yes.
Okay. All right, so by way November 27th of 2015, the petitioner was a victim of domestic violence. On March 7th of 2018, USCIS received the petitioner's U visa application. And on September 27th, 2018, the petitioner's motion to continue was denied and she was ordered removed. The immigration judge abused his discretionary powers when he failed to consider all of the good cause factors laid out in matter of Hashmi, matter of Sanchez Sosa, and matter of LABR. Specifically, the immigration judge in his written decision, I believe that's Administrative Record 42, listed 6 factors that an immigration judge should consider when determining whether good cause has been established. The first factor, Your Honor, is the likelihood that the alien will receive relief. The second is whether the relief will materially affect the outcome of removal proceedings. Those first 2 factors, Your Honor, as a matter of LABR specifically stated, are the primary factors that should be taken into consideration among germane secondary factors, which I'm going to go through right now, which is number 3, whether the petitioner has exercised reasonable diligence in pursuing that relief. Number 4, DHS's position on the motion. Number 5, the length of the requested motion. And number 6, the procedural history of the case. In the immigration judge's written decision, the judge only discussed 4 factors out of the 6. Furthermore, the immigration judge erred when he improperly included DHS's opposition to the motion to continue as one of the reasons for denying the motion. In the transcript of hearing dated September 27th of 2018, that's Administrative Record, I believe, 70, the immigration judge denied the motion to continue before DHS stated that she opposed the motion, nor was a motion ever filed by DHS. How could the immigration judge say that he considered—
Counsel, I'm sorry to interrupt you. Sorry to interrupt. I was under the impression the BIA wrote its own opinion. And if so, isn't that the opinion we review, not the IJ's?
They did write their own opinion, but in their own opinion, they basically, in essence, agreed with everything the immigration judge stated. So
is that what they said, or did they give their own reasons? I thought they gave their own reasons.
In my view, Your Honor, it looked like they stated the same reasons that the immigration judge.
Yeah. The reasons certainly overlapped with what the IJ found, but I don't believe the BIA said we adopt and incorporate the IJ's decision. Instead, they said we've reviewed these factors and we evaluate them in such and such way, which is the same way that the IJ had evaluated the factors.
You're absolutely correct. The board did say that. They didn't just summarily agree with the immigration judge, but they, in essence, they did say the same thing. But I understand your point, Your Honor, and you are correct. So moving forward, I will just address the board's opinion. I believe that's what you're implying. Is that correct, Your Honor?
I take your point that what the IJ did, but I think if we're looking at the factors, we should probably be looking at what the BIA was saying about the factors.
Okay. So in that instance, Your Honor, the BIA did also erroneously include DHS opposition as well. They agreed with the immigration judge that that weighed heavily in favor, or not in favor of the petitioner. But again, DHS never made an opposition to the motion prior to the immigration judge making his decision. And then the board also did the same thing. They included DHS's opposition as a reason to not grant the motion to continue. But again, that was never mentioned before the motion to continue was denied. So I don't understand how either the immigration judge or the board could take that into consideration for good cause. The next point, the next factor that was taken into consideration by both the immigration judge and the board was the likelihood the alien would receive the collateral relief. Now, the board acknowledged that the immigration judge stated in his written decision that the petitioner has a significant probability of succeeding with her U visa, but then neither the immigration judge or the board give it the proper weight. They just simply state that, yes, she does have a significant chance, and then that's it. The Attorney General, in matter of LABR specific, yes, Your Honor.
Counsel, I mean, kind of somewhat related to Judge Rushing's question, the immigration judge, identifies the likelihood of success. And I understand you say it may not be enough weight, but does the board identify that as a factor?
I believe the board did as well.
I'm not, I mean, they list it as a factor, but I don't know, other than listing as a factor, they discuss it.
Let me just check the record. You may be absolutely correct, Your Honor. The board may not.
And I think this becomes a pretty big issue as to whether you believe that the board adopted the immigration opinion or whether it did not. I mean, it sounds, do you have a position one way or the other on that?
I mean, I do think that the board, so they did make their own, kind of their own reasoning, but their own reasoning was the same conclusion as the immigration judge. And I think you are correct, Your Honor. I don't think the board actually took in consideration the success of the U visa, the significance of that. I think that was only the immigration judge in his written decision. But I don't think the board actually made a rational explanation on that point. And I think that's huge because, again, in matter of LABR, they say, the Attorney General stated that is one out of the two primary factors that should be taken into consideration. And now I do understand that germane secondary factors are also important, which both the immigration judge and the board did consider. But again, both of them cherry picked with what fit the decision that they wanted. They chose only the factors that they felt went against the petitioner and didn't include all of the relevant factors when there was more in favor of the petitioner. For example, the length of the continuance requested. That's one of the relevant factors that matter of Hashmi states, matter of San Francisco, matter of LABR states should be taken into consideration due to the relevance of it. And it was not. And also, it was at the behest of an immigration judge in Atlanta who wrote specifically on the change of venue that the judge could reset this case to a status docket in June of 2019, which was the following year. And the immigration judge completely disregarded that. And so did the board. They didn't even give an explanation as to why they weren't going to take that note, that instruction from the jurisdiction into consideration. And then another relevant factor that was not taken into consideration was the length, how long it took for her to file her U visa before review. She was a victim of domestic violence in 2015. And she had already submitted her application to USCIS by March of 2018. That's just a little over 2 years, Your Honors. And in my opinion, that is a very reasonable amount of time to get your U visa application filed with USCIS. One being the police report certification. That takes time to get certified. That's at the discretion of the police department. We all know that police departments are extremely busy. And so there's no time limit on that. They send it to us when they want. Apart from that, that's step one, we have to file the U visa application with USCIS. While the U visa itself is free, doesn't have a filing fee. The waiver application, the I-192, has a $930 fee associated with it and is necessary to submit at the same time with the visa to not cause further delays. And so she did all of this in just a little over 2 years, which neither the immigration judge nor the board took into consideration. They completely overlooked that, which is one of the factors laid out in matter of Hashmi, in matter of Sanchez Sosa, in matter of LABR. And the board didn't even follow its own. Again, the board just cherry picked the factors that fitted the outcome. Another factor that was taken into consideration was by both the immigration judge and the board was administrative efficiency. The immigration judge and the board discussed that administrative efficiency was a factor weighing against good cause. The immigration judge stated that because of the length that it takes for a U visa to process, it would be inefficient for the courts to ever continue the case where there's no pending relief. Now, at the time of the removal hearings, it was 2018. The processing times for a U visa were 2 years. The immigration judge stated this on the record during the September 27th hearing. As such, granting one continuance for a year at the behest of another immigration judge in Atlanta would not have burdened the courts at that time.
Was the BIA correct that there were no applications for relief?
Yes, Your Honor, and I'm glad that you brought that point up, because in counsel's brief and Oil's brief, they mentioned throughout their entire brief that the petitioner deliberately did not file any relief. And while, yes, that may be the case, but that's not the entire truth. She didn't have any relief available to her in the immigration court. She did not express a fear of returning to her country. She said that she came here for a better life. Thus, that rules out effectively asylum, withholding of removal, and CAT. The only other options would have been 42B cancellation of removal, which she didn't meet the 10 years continuous presence, among other factors. And the last factor the last relief would have been voluntary departure, but we didn't even get that option to discuss it because she only had one hearing in Charlotte, and then her motion to continue was denied, and then she was ordered removed. We didn't even get another hearing to discuss the option of voluntary departure, which would have actually been a little more beneficial to her case with the U visa pending. But we didn't get to that point. Instead, the judge just rushed her through the court system and ordered her removed. And that is the very reason why we're here today, Your Honors, because the immigration judge and the board didn't follow their case precedent. They didn't take into consideration all of the factors relevant for good cause. And they're supposed to put it in a balancing test prior to making their decision. But instead, the judge and the board made a decision and then cherry-picked out of all the case precedent which factors went in favor to their decision. And Your Honor, that is incorrect, and that is why there's so many of these cases burdening the courts right now in appeals, because immigration judges are constantly, I'm not going to go into other cases, but at least specifically in this case, the immigration judge and the board didn't follow their own case precedent, and that is the essence of this entire appeal, this case, and why we would like for this case to either be remanded back to the immigration court for further review under matter of LABR, under matter of Sanchez Sosa, under matter of Hashmi. I mean, pick a case. There's so many that clearly list out the factors that you're supposed to take in consideration, all of them, and balance them out and then make a decision. But that wasn't the case here, Your Honors. And on top of that, an immigration judge specifically instructed the judge in Charlotte to set it for a status docket a year out in light of her pending U visa. And he didn't even do that. Instead, he went on the record and said that judge in Atlanta, it's in the transcript of hearing, it was a friend of his and a colleague of his, and that he was shocked that he would even suggest for him to put this case on another docket for the next year. He kind of went on a rant and vented about what his colleague, and he even said his friend, suggested him to do, but then didn't give a rational explanation for why he wouldn't at least consider that instruction from a sister jurisdiction. It was an utter abuse of discretion, Your Honor, and Your Honors. And I mean, to me, it is clear in this case that the immigration judge and the board both abused the discretion and to consider case precedent, Your Honors. And Hopefully we can get this down today or in another day and figure out how these judges need to balance all these good cause factors when determining a motion to continue. This is my time is up, Your Honors. If you don't have any further questions, I'll reserve my time for rebuttal.
Thank you. Happy to hear from the government. Your microphone's not on.
Good morning, Your Honors. May it please the court. Therese Pratt for the respondent, Merrick Garland. The court should deny the petition for review. The agency acted well within its discretion in denying the motion for a continuance while Ms. Cabrera pursued a U visa. The agency rationally...
Counsel?
Yes.
The BIA may be found to have abused its discretion when it inexplicably departs from established policy. That's one book law, right? You would agree with that?
When it inexplicably departs, yes.
Explicitly departs from established policy. Now, didn't the BIA here inexplicably depart from established policy?
No, it did not, Your Honor.
Okay, well, let me just tell you what I think the policy is and what I'm referring to. And that is that the BIA and the Attorney General have long followed an established policy regarding when to grant a motion for continuance if the movement has a pending IJ visa application. They did it in Manter, they talked about it in Manter Sanchez, in matter of LABR, and most recently in matter of LNY. And the end result of all of those cases is the primary factors, not the only factors, but the primary factors are the likelihood that the application of the U visa will be granted and that it will materially affect the outcome of the removal proceeding. Is any of that wrong?
Yes, those holdings are correct, but the primary factors, they were not dispositive in matter of LNY.
That wasn't my hypothetical. Those are the primary factors.
Correct.
And we know that if the BIA does not follow established procedures, and the established procedures tell you to look at these primary factors, it's reversible. Now, where did the BIA look at those two primary procedures?
First, the BIA found that they agreed with the immigration judge's decision to deny the request.
Okay,
they pointed out.
If that is so, then we go look at what the administrative judge's opinion was, right? I thought that you just wanted to rely on this page and a 10th opinion from the BIA. If we go back and look at what the AJ did, that's an administrative, the judge did, that's a whole different thing. So are we to go back and look at what he said?
You didn't let me finish. So I said that the BIA agreed with the immigration judge's conclusion. The BIA pointed out that the two principal factors for consideration are whether the likelihood the alien will receive the collateral relief and whether the relief will materially affect the outcome of the proceedings. Right. Then the BIA went on to say that there are other important considerations, including DHS's position on the motion, the length of the continuance, administrative efficiency, and any indication as to when relief will be approved.
Where did they balance in the two most important factors?
They acknowledged those two factors.
I know they acknowledged them.
They agreed with the immigration judge who had pointed out those factors.
If they agreed with the immigration judge, then are you saying they agreed with the immigration judge's rejection of his analysis of those two factors? Is that what you're saying?
Yes. The board agreed with the immigration judge.
So, then the immigration judge expressly said that there was a likelihood that she would get this relief, right? But the immigration judge said that whether the relief will materially affect the outcome of the removal proceedings is the problem, right? That's what the immigration judge said.
And the likelihood that she will get it is not 100%.
No, but I'm not saying it's 100%. I'm saying it's a likelihood, right? That's what the
and they balance that.
I think we're here on common ground. The immigration judge said what the immigration judge said, right?
Right. And they balance that with the secondary factors, which, if you look at Sanchez Sosa, it says a prima facie approvable U visa application must also consider any other relevant factors such as administrative efficiency. And if you look at matter of LNY, the primary factors were not dispositive in matter of LNY, and they are not dispositive here. They looked at DHS's opposition.
Can I ask you the question? Is it the government's position that it is never proper for an IJ to grant a continuance based on a pending U visa application?
It's the government's position that it's never proper to grant. That's not the government's position.
Okay, what factors would have to be different?
It's always case by case. None of the factors are.
But we have this case now.
Absolutely.
And
looking here, they looked at DHS's opposition, and the fact that she was a public safety concern, where she was involved in a hit and run, causing serious injury that left the person to die in the middle of the road. And DHS brought a witness to testify at that hearing. If you look at pages 68 to 69, DHS was strongly opposed to a continuance. And as recently as last month,
for the board, are these
excuse me,
for the board? I'm just looking at the board's proceedings.
Yes.
And what the board said.
And the board said they agreed with the immigration judge's concerns about administrative efficiency.
I understand they said that. So do we go back and look at what the immigration judge said? Does that mean that and we look at the evidence before the immigration judge?
When the board cites to that, then you can look at what the immigration judge said with respect to that, because the board is agreeing with the immigration judge's decision in those areas. And the board said they cited the lengthy processing time.
Counsel?
Yes, I'm sorry.
Hey, Counsel, this is Judge Quattlebaum. I'm just trying to. I got two steps and about how I want to make sure I understand things here. It sounds like you're saying that the statement, "We agree with the immigration judge's decision to deny the respondent's request for a continuance," allows us to look at the immigration judge's decision. Is that your position? Okay.
Yes. In this instance, yes.
All right. Because
they didn't say they adopted and affirmed, but they said they agreed with it, and then they sent out. They said that while the two principal factors for consideration, there are other factors, other important considerations, and then they went on to list them.
Okay. So let me just go step by step. If you could, let me go through this. If we were looking at the BIA opinion solely, not incorporating the immigration judge's opinion and reasons, do you think the BIA adequately addressed all the factors? Just the BIA, not the BIA plus IJ?
I believe it did, and I will tell you why. They said they agreed with the conclusion. They said there are two principal factors. Then they said there are other important considerations. And in this instance, they found that those other important considerations outweighed the two primary factors. So we all know what the two primary factors are. They didn't list them again in the third paragraph. They just went on to list the secondary factors that they thought outweighed those two primary factors.
Well, do they ever, if I could just finish, Counsel, do they ever say that, does the BIA say those secondary factors outweigh the primary factors?
Yes, the third paragraph. We are not persuaded that good cause for further delay of the proceedings was demonstrated. And they said she was found removable. She did not submit any applications for relief. Therefore, a final order of removal could properly be entered. And then they go on to say that the final order would not prevent her from continuing to pursue her U visa with DHS, and that DHS could grant her a stay of removal, and that DHS opposed the continuance. And they agreed with the immigration judge's concerns regarding administrative efficiency.
Right. So it looks to me like they're giving reasons, and those may be all good reasons, but looking at the BIA's opinion itself, it lists the two primary factors, but it doesn't address how they come out in this case. If you look, I'm concerned a little bit about that. If you look at the IJ's opinion, I think the IJ, does a better job of listing all the factors. The trouble with the IJ's opinion is twofold. Number one, was it actually incorporated? And I understand you think it is, and that may be right, but it wasn't as explicit as it is at some kinds. And the other problem with the IJ's opinion is it lists this issue about whether the relief will materially affect the outcome of the removal proceedings. And the IJ said it did not. And it said it did not because the IJ, couldn't grant that relief. And that seems to be
no.
No.
It also said USCIS has sole jurisdiction over applications for adjustment of status based upon an approved and current U visa. And so if you understand the U visa process, it's a many-tiered process. You first have to apply, then you have to get, it's years. She's like at least 2 years away from even getting the application looked at.
Right.
And then there's 3 years on the waiting list. And then she has to apply for adjustment of status. And that's all discretionary. That's what the IG was pointing out. That's why it's not clear where DHS opposes, where DHS feels that she's a public safety risk. It's not clear that she will be approved.
It's generally good form to let the judge talk.
Yes. Sorry.
I'm okay, and I appreciate your passion. But it seems to me, and what you're talking about, length of delay, I mean, those I think are legitimate factors for sure, and your points are well taken. But it seems to me that the factor is whether the collateral relief, a U visa application, would affect the withholding decision. And as I understand the U visa process, if it's granted, then you would not be removable.
Well,
right?
She has to adjust status, and that is discretionary. And DHS has pointed out that she is a public safety concern, and they have refused. Okay.
Yeah, so she may lose it. I get you, but if successful, they said it was likely to succeed, and if it's successful, it would have adjusted her status, and that would mean No. She's likely to succeed in having the U visa granted, but she still has to adjust her status, and that is completely discretionary. And USCIS has identified her as a public safety risk. And actually, opposing counsel requested prosecutorial discretion, and as recently as August 11th, 2021, DHS denied it. They said that her equities are insufficient to overcome the public safety concern presented by the facts underlying her criminal conviction. Well, go ahead, Judge Motz. That's new information that's not before us, but I mean, I appreciate that point.
Well, but the test is not that it would get her relief necessarily, but it would materially affect. And of course it will materially affect. There's no question about that. In other words, it would have any effect at all.
If she's denied adjustment of status, if
they would continue to, but if they saw she got this other visa, they might not.
It's all the same agency. It's all the same agency. It's USCIS under DHS. And DHS is saying she's a public safety risk, and they're refusing to exercise prosecutorial discretion.
Okay, so is that the reason that they gave? Is that
the reason they gave was that DHS opposed. And if you look at the transcript on page 68 to 69, DHS says that she was involved in the hit and run and left someone to die in the middle of the road, and they brought a witness to testify.
Okay.
And so DHS strongly opposed this. Yes.
Counsel, I understand that the agency opposed it. Does the agency say that it opposes this because it will never accede to her getting the visa?
No, the agency doesn't say that.
The facts. We don't know what the underlying facts are.
Right. But this is not an abuse of discretion where the judge weighs all the negatives, considerable negatives, and the positives, and the length of time. She's asking essentially for that to stay on the docket for 7 years, because it's like, we are now at 2021 and she's 2 years away.
But that's what always happens when you have this visa application, right? This is nothing extraordinary.
Well, when you balance all the factors, the fact that she's a public safety concern,
ma'am,
the fact that
remember what I told you about letting the judge talk? After all, you want to know what we're thinking, right?
Yes.
I mean, because you're not going to be able to make the decision, we are, right?
Correct.
So remember I asked you a long time ago if it's ever proper for an IJ to grant a continuance based on a pending U visa application. And you said yes, I think.
It all depends on the facts and circumstances. They look at the primary factors.
Direct answer to that question, yes or no?
You said, is it ever proper? Of course. In some instances, it's proper. Not in this one. In this one, the secondary factors outweigh the primary factors. And we saw that in
Can I
matter
ask
of
a
L and Y.
procedural question? I was curious about whether the pending U visa proceeding would be considered and have an impact if there were pending applications for relief. So in a different case, so obviously the petitioner here is not seeking asylum, withholding. She's not seeking any relief that IJ could grant currently. But if there were a pending asylum application or a pending withholding application, would the U visa proceedings potentially affect those or affect the outcome of that, or would it still not be?
I would imagine
would it still not be relevant?
I would imagine that it would be more relevant because she's seeking some relief from the immigration court that they can give her. So maybe that would be more amenable to continuances, because she'd have to get evidence for the asylum, for withholding and torture. So I would imagine in a case where she was seeking other types of relief, that would be more amenable to a continuance, rather than you're here, you don't want anything from me, you're looking for relief from another agency. You can get a stay from that agency. Well, I can't do anything. You're on my docket for 5 years, 7 years. I'm carrying your case. There's a 1 million case backlog of immigration cases, and you're not the only one. So it's like, why carry this case for 5 years, 7 years? We're in 2021.
Just to follow up one procedural question. So does what happens in the U visa process, does that have any different impact if there is a application pending that an IJ would need to know and take that into consideration when assessing asylum, versus a situation like this where there's no application for relief and it's just a matter of entering the removal order? Would there be any information that he would get from the U visa process, or is it just it's entirely separate in both situations?
It's entirely separate, collateral, another agency. IJ has nothing to do with it. Only, are you seeking asylum, withholding, torture? Is there some relief that you're asking the IJ that he can give you? And if he can't, then why is your case sitting there for many, many years when there's a 1 million case backlog, and you can get the same stay from DHS? And if there are no further questions, I would rest on the brief.
Thank you very much.
Thank you.
Is there any rebuttal?
Yes, Your Honors, and may it please the court. So I'm just going to briefly address a couple points that I feel are the most relevant coming after hearing counsel. First and foremost, I want to address the hit and run conviction, because I think it's a very nice way to distract from the issues here at hand, because the immigration, and neither did the BIA take into consideration that conviction on her record at all. When assessing good cause, neither of them took that in consideration. DHS made a comment about it in the hearing, at the end of the hearing, after the judge already denied the motion to continue and was saying that he was going to order the respondent removed. Excuse me. So, and even in the transcript of the hearing, the judge goes, well, what do you want me to do with that? it's already been decided. And at that point, it's kind of irrelevant for all intents and purposes. He already denied the motion, and he already ordered her removed. Furthermore, that conviction did not have serious injury. She was convicted of hit and run with minor injury, which is a misdemeanor in South Carolina. So that is also a misstatement that you're trying to gear the issues here in a different direction when that hit and run has nothing to do with the good cause factors for a motion to continue in this case, because neither the judge nor the BIA took that in consideration. As it relates to the prosecutorial discretion request, yes, we did file 2 requests with DHS, and they were both denied solely because of that hit and run. And it was the same counsel from DHS who conducted the hearings that I was working with, and she refused to grant any discretion just because of that hit and run. And I will just say for the record that the judge in Atlanta granted the petitioner a bond knowing of that hit and run charge, because in his decision, he specifically stated that she had far more positive equities that weighed in her favor than this single conviction on her record, which was a misdemeanor and which caused minor injury, not serious injury. That's what she was charged with, but what she actually was convicted of was minor injury, which is a misdemeanor. That is a huge difference, but regardless, it's irrelevant in this case because it wasn't taken into consideration by the immigration judge nor the Board of Immigration Appeals. And Judge Quattlebaum, just to go off what you were saying earlier, you are absolutely correct. The BIA did not take into account the likelihood of success of the petitioner's U visa claim. They mentioned it as one of the factors to take into consideration, but then didn't even address it in their written decision. So it again just shows that the immigration judge and the Board of Appeals both already had a decision made in mind and then cherry picked what factors. I keep saying that, Your Honors, because it is so important to this case that they cherry picked factors specifically that weighed against the petitioner and did not include factors that weighed in favor, besides stating that she has a good chance of succeeding on her U visa claim. And the question is, these victims, because they're victims of a crime, they should be afforded at least somewhat of discretion, whether small or large, because they are victims of a crime committed in the United States. In this case, it was domestic violence, where she was choked in front of her child, her minor child. The guy was a United States citizen, and he was charged with criminal domestic violence in the state of South Carolina. That should have also been taken into consideration, the nature of the crime that was committed against her. It was very, very serious and very brutal, hence criminal domestic violence. And she assisted law enforcement with everything that they needed and with the prosecution of her ex-boyfriend at that time. And that is the very reason why victims of a crime are afforded a special kind of discretion because of the nature of what they went through. And Your Honors, I can't say it enough, but I do think that either this case needs to be remanded back to the immigration court for further review consistent with case precedent, or in the alternative, I think this court needs to establish a bright line rule, if I may be so bold, a bright line rule for immigration judges and the board to follow, if we don't keep burdening the courts, the BIA and this court with this issue. Clearly, the judges and the board are running rampant, cherry picking, and they need to be taking all relevant factors in consideration, balancing them out, and then making a decision. Whether favorable or not, I would not appeal a case if the judge had done all of that and gave a rational explanation for his decision. I would not appeal it had he denied it. And if you have no further questions, Your Honors, I see I have 5 seconds left. Thank you so much, and I appreciate your time.
Thank you both for your very vigorous arguments. We'll ask the clerk to adjourn court for the day.
Thank you, Your Honors. I appreciate it.
The Honorable Court stands adjourned until this afternoon. God save the United States and this Honorable Court.
Judges, I will move you into the roving room now.
Okay, thank you.